witness of the defense. Although the court may rely on evidence elicited from the defense which supports the claimant's case, it's equally settled that final written addresses, however brilliant, cannot take the place of evidence, referring to the case of Odunleye against General Oil Limited 2014 citation provided and the case of Buhari and INEC citation provided. Learned Claimant Counsel submitted that the evidence before the court established that the allegation against the claimant was false from inception and that the defendant acted maliciously in causing his arrest, detention, and prosecution, despite the medical findings. Counsel argued that the order of discharge made by the magistrate court reinforced the claimant's case, that the prosecution lacks merit, and urged the court to hold that the ingredients of malicious prosecution, defamation, false imprisonment, and the other causes of action has been satisfactorily proved. He relied on the number of judicial authorities in support of his submissions and urged the court to grant all the relieved claim. Learned Counsel for the third defendant, on the other hand, urged the court to dismiss the claims against his client. He urged that the evidence established that the University Security Department mainly performed its lawful investigation functions before referring the complaint to the police, and that no credible evidence connected the third defendant with any malicious or unlawful act. Counsel submitted that the burden of proof proving the essential increment of the torts alleged rested throughout on the claimant and that such burden has not been discharged. Having carefully considered the pleadings filed by the parties, the evidence placed before the court, the documentary exhibits admitted in evidence, and submissions of learned counsel, it is therefore necessary to evaluate the totality of the evidence before determining whether the claimant has established his case on the balance of probabilities required in civil proceedings. Before embarking upon the evaluation of the evidence, I consider it appropriate to observe that although the claimant founded his action on several causes of action, namely malicious prosecution, defamation, and claims for special and general damages, the determination of this suit ultimately depends upon the resolution of few fundamental questions arising from the evidence before the court. This includes whether the allegation made against the claimant by the first defendant was false and malicious, whether the first and second defendant actively procured or continued the criminal prosecution without reasonable and probable cause, 3, whether the third defendant merely discharged his statutory duty as head of the University Security Department or acted outside the scope of the official responsibilities, 4, whether the alleged publication constituted actionable defamation, and finally, whether the claimant has discharged the burden of proof imposed upon him by law in respect of this relief sought. Necessary also is to further appreciate the fact that the final addresses, however brilliant, cannot substitute evidence. They mainly assisted the court in appreciating the legal implications of the evidence already before it. Consequently, the decision of the first and the second defendants to waive their rights to file a final written address neither strengthens nor weakens their case. Their evidence remains part of the record and must be evaluated alongside the evidence adduced by claimant and the third defendant. In the present case, certain facts appeared not to be in controversy. It is common ground that on 5th of November 2023, an incident occurred within the premises of the University of Maiduguri involving the claimant and the first defendant. It is equally not disputed that following the incident, officials of the University Security Department intervened. Both parties were taken to the university clinic for medical examination. The matter was eventually referred to the Nigerian police, resulting in criminal proceedings before the Chief Magistrate Court, Maiduguri. It is also beyond dispute that those criminal proceedings did not proceed to a determination on the merit, but were struck out by the Magistrate Court for want of diligent prosecution. The principal area of disagreement lies elsewhere. The claimant insists that the allegation made against him was fabricated from the outset, since the medical examination immediately disproved the allegation, that notwithstanding such knowledge, the defendant maliciously ensured that he was detained and prosecuted. The defendant, on the other hand, maintained that each of them acted within the limits of the law and that none of them acted maliciously or without reasonable cause. The court has carefully examined the documentary evidence pleaded by the parties, particularly the proceedings on ruling of the Chief Magistrate Court delivered on the 5th May 2025. The significance of that ruling cannot be overstated, as both parties have attached considerable legal consequences to it. Let me begin with malicious prosecution. The claimant contention that the order of the discharge conclusively demonstrates that the complainant has baseless. The defendants argue that the order merely terminated those proceedings for want of diligent prosecution and did not amount to judicial declaration that the allegation itself was false. In my respective view, the true legal effect of that ruling must be appreciated within its proper context. The learned magistrate did not evaluate the evidence of witnesses or pronounce upon the guilt or innocence of the accused after a full trial. Rather, the court exercises its statutory powers upon finding that despite numerous adjournments extended over a considerable period, the prosecution had failed to diligently prosecute the case. The order therefore established without doubt that the criminal proceedings terminated in favor of the present claimant. Whether that fact alone is sufficient to sustain the thought of malicious prosecution is, however, an entirely different question. Be that as it may, the law has consistently maintained that the thought of malicious prosecution is not established merely because criminal proceedings terminated in favor of an accused person. A claimant must further establish that 1. The defendant instituted or was instrumental in instituting the prosecution. 2. That the prosecution terminated in his favor. 3. That it was instituted without reasonable and probable cause. 4. That it was actuated by malice. The absence of any one of these ingredients is fatal to the claim. The Court of Appeal, in the case of Mabas against Mohammed, 2025 citation provided, emphasized that, and I quote, all of the above elements must be proved conjectively. Failure to satisfy any of the elements will be fatal to the claimant's case. This clearly indicates that proving only one element, such as the termination of proceedings in favor of the accused person, is insufficient. Furthermore, the element of malice must also be proven. Referring to the case of Associate Boscom PLC against Eze, 2022 citation provided, the appellant submitted that malice, an essential element, was not proved, and that a mere discharge will not ground the thought of malicious prosecution. This reinforces the position that termination in favor, even by discharge, is not enough without proof of malice. On this regard, the liability of the defendants therefore depends on proof that he or they actively instigate or procure the arrest, detention, or prosecution complained of. What is more, in paragraph 21 of the witness statement on oath of the claimant, which he adopted on the 7th day of April 2026, it was stated as follows, and I quote, that since parties could not settle amicably, the first and the second defendants urged the third defendant to refer the case to Gonge Police Station, and Gonge Police Station subsequently transferred the case to headquarters. This position presupposes that there exists a disagreement as regards amicable settlement of the contention between parties, even though the assertion was refuted by the first and second defendants in paragraph 13 of their joint statement of defense, where they averred that it was the university authority that referred the matter to Gonge Police Station, which in response thereof, claimant stated that he stood by his earlier averment. All this averment without more cannot tilt the pendulum in claimant's favor, as they fall short of the requirement of establishing what claimant is trying to place before the court as regards malicious prosecution. Consequently, even though the criminal charge was struck out for the reasons advanced above, a claim for malicious prosecution must fail, and it has, in all substance, failed in the case at hand, I so hold. On the claim for defamation, the court must determine not merely whether unpleasant words were spoken concerning the claimant, but whether the words complained of were published by the defendants, whether they referred to the claimant, whether they were defamatory in their natural and ordinary meaning or by innuendo, and whether the claimant has established the injury alleged to have flown from such publication. In the Supreme Court decision of Abalaka against Akinsete and others 2023 citation provided, requires a plaintiff in an action for defamation to prove 6 contumacious ingredients, namely: 1. Publication of offending words by the defendant. 2. Publication of third parties, meaning that the label or slander must have been published to a person older than the plaintiff. 3. That the words complained of refer to the plaintiff. 4. That the words are defamatory of the plaintiff. 5. Falsity or lack of accuracy of the words complained of. The plaintiff must prove that the defamatory words are untrue. 6. That there are no justifiable legal grounds for the publication of the words. This relates to the absence of defenses such as justification, fair comment, or privilege. The liability of the first defendant, if any, must necessarily depend upon the evidence establishing that he knowingly made a false allegation without reasonable cause. As pointed earlier in the instant case, there is no dispute that an unfortunate incident occurred on the 5th November 2023 within the University of Maiduguri during the first defendant's accused claimant of stealing his manhood. There is equally no dispute that the accusation immediately attracted public attention, resulting in claimants being assaulted by the members of the public before officials of the university security departments intervened. It is also common ground that both the claimant and the first defendant were taken to the university clinic for medical examination, and thereafter the matter was transferred to the Nigerian police, which subsequently instituted criminal proceedings before the Chief Magistrate Court. These undisputed facts considerably narrow the issue requiring determination. The real controversy is whether the conduct of the respective defendants before, during, and after the incident amounted to actionable civil wrong or of defamation for which damages may properly be awarded. The claimant's case rests substantially on the preposition that the medical examination conducted shortly after the allegation establishes beyond question that the complaint made by the first defendant was false. According to him, once the medical examination failed to support the allegation, and considering the circumstances of this case, vis-a-vis the ingredients of the charge of defamation, the claim has been substantiated. The court therefore observed that the allegation complained of, namely that the claimant stole the first defendant's manhood, is one which, if falsely made and published, is undoubtedly capable of lowering the claimant in the estimation of right-thinking member of society. What is more, there is no argument that accusing the claimant of stealing the first defendant manhood is defamatory. Such an allegation is plainly capable of lowering him in the estimation of right-thinking member of the society and exposing him to hatred, ridicule, and contempt. The evidence established that the first defendant made the allegation publicly in the presence of several persons. The immediate reaction of the crowd, which descended upon the claimant, demonstrates that the allegation was communicated to third parties, thereby presupposing that the publication has therefore been established. The oral evidence of CW2 further established that upon examination, the first defendant's genital organ was intact and medically normal. On the strength of the above findings, I therefore find that the allegation made against the defendants was false. The court is satisfied that the claimant has established the ingredients of defamation against the first defendant. With respect to the third defendant, the pleadings disclose a defense founded essentially on statutory duty. The case presented by the University Security Department is that it merely responded to a complaint made within the university community, conducted preliminary inquiries, facilitated medical examination, and thereafter referred the matter to the police because the allegation disclosed the commission of an alleged criminal offense. If that account is accepted upon evaluation of the evidence, the mere fact that the complaint subsequently failed will not necessarily impose civil liability upon the officers who discharged their investigative responsibilities in good faith. On the other hand, if the evidence demonstrated that despite knowledge that the complaint has completely collapsed, the security department deliberately procured or encouraged the continued detention and prosecution of the claimant, a different legal consequences may arise. It is therefore imperative that the evidence relating to the conduct of the security officials has scrutinized with considerable care. The position of the second defendant similarly requires separate consideration. His liability cannot be in fraud, mainly because he is related to the first defendant or was a staff member of the university. The law requires proof of personal participation, instigation, or procurement of the act complained of, unless the evidence established that actively influenced the area, detention, or prosecution of the complainant or participated in a conspiracy to injure him. No liability can properly attach him merely by association. The court must also exercise caution in relation to the campaign material, social media publication, public notices tendered by the claimant. While those documents may demonstrate that the incident attracted widespread publicity and the attempts were subsequently made to restore the claimant's reputation, they do not, without more constitute proof of the truth of the factual assertion contained therein. Their probative value will depend on the purpose for which they were tendered and the evidence linking them to the issue before the court. The court, in its finding, did not find where the claimant led evidence tying down the second and the third defendant in any way, shape, or form to the claims made before the court. Therefore, there is no evidence that either the second or the third defendant authorized or republished the defamatory words. The mere circulation of videos on social media cannot, without credible evidence, be attributed to them. Accordingly, the claim for defamation succeeds only against the first defendant. I so hold. I now consider the claim for the special damages. The claimants claim 241,000 naira being the value of personal belongings allegedly lost during the incident, together with 25,000 naira allegedly expanded on medical treatment. The law admits of no controversy that special damages must not only be specifically pleaded, but must also be strictly proved by credible evidence. In Fidelity Bank PLC against Searchcom Concept Limited and another 2025 citation provided, the Supreme Court held that special damages must be specifically pleaded, strictly proved by credible evidence. This principle was also affirmed in the case of Adebi against the Sliver and others 2024 citation provided, which held that for special damages to be awarded, besides being specifically pleaded, they must be in respect of claimable head of damage, and that the special damages should easily lend themselves to quantification or assessment and be supported by credible evidence. Although the claimant pleaded the sum claim, he failed to produce satisfactory evidence establishing either the value of the alleged lost items or the medical expenses incurred. In the absence of the strict proof, those claims cannot succeed. Accordingly, it is hereby adjudged that the claim for special damages cannot succeed, and same has failed for lack of consent with the particulars. However, having founded that the publication made by the first defendant was defamatory, false, and injurious to the claimant's reputation, the relief is well founded. Accordingly, the first defendant is hereby ordered to publish a written apology to the claimant within 30 days from today in substantially the same medium through which the defamatory allegation was circulated, and where there is no longer practicable, in at least one widely circulated newspaper operating within Borno State. In assessing damages for defamation, the court has considered the gravity of the allegation, the circumstances in which it was made, the extent of its publication, the humiliation suffered by the claimant, and the fact that the accusation immediately exposed him to mob violence and ridicule. Consequently, general damages against the first defendant in the sum of 1 million naira is hereby awarded. Similarly, cost follow events. Although the claimant has failed in the greater part of his claim, he has succeeded in establishing the claim of defamation against the first defendant. It is therefore just to award a moderate cost. Accordingly, I award the sum of 300,000 naira as cost in favor of the claimants against the first defendant only. In the final analysis, the claimant succeeds only in part. For clarity, the order of the court is as follows. 1. The claim of 241,000 naira, being the value of the alleged loss personally belonging, is refused. The claim for 25,000 naira, being reimbursement of medical expenses, is hereby refused. The claim for general damages for malicious prosecution is dismissed. The claim for general damages for defamation succeeds against the first defendant only. The first defendant shall pay the claimant the sum of 1 million naira as general damages for defamation. The first defendant shall publish a written apology to the claimant within 30 days in the manner earlier directed. So the claims against the second and third defendant are dismissed in their entirety. The first defendant shall pay 300,000 naira as cost of their action. That is the judgment of the court.
Ascop, please.
Yes, registry.
Yes, my lord. That's all.
My lord, we thank my lord for the well-considered judgment. It is a prayer that God Almighty will guide my lord more and more in the dispense of justice to humanity. We are this grateful, noble Lord, for the well-considered judgment.
Yes, thank you. Yes, is there anything on the cost list?
Thank you, my lord, for the...
That's
The absence of anything on the cost list is a caution.